Welcome back to the channel today, guys. Just wanted to do one today. I know that I've had questions about this in the past. Sometimes we have some financial issues that come up in our lives. And I was always curious, can my VA disability be garnished like a normal paycheck? And I did the research on it. I have the podcast I'm going to put up for it. Hope you guys enjoy it. I would listen to it. It's got the information in there that you're going to want to need. If not, I will put at the very end just a quick snapshot of what can and what can't, and we'll go on from there, and I will catch you in the next video.
Welcome to the Deep Dive. Today we're digging into something really vital for veterans. Can creditors actually garnish your VA disability benefits? And, the surprising answer right off the bat for most private debts, think credit cards, car loans, medical bills, is a clear NO.
That's right. There's a very strong federal law, 38 U.S.C. Section 5301. It acts like a shield. It makes these benefits exempt from creditor claims, basically untouchable. And crucially, this protection follows the money, even after it's sitting in your bank account.
Okay, untouchable. That sounds pretty solid.
It's designed to protect the veteran and their family, making sure the money serves its purpose.
So our mission today is to, really unpack this shield, look at the edges, the very limited exceptions, and figure out how to make sure that protection actually works in your bank account and what you need to do if someone tries to target those funds incorrectly. So this bedrock law you mentioned, 38 U.S.C. Section 5301, it says benefits are exempt from the claim of creditors and shall not be liable to attachment, levy, or seizure. That language sounds incredibly strong.
Yeah, it absolutely is. And the key phrase in there is either before or after receipt by the beneficiary. That's the part that confirms the protection extends into your bank account.
Right, after receipt.
Yeah. And there's also an anti-assignment clause. Basically means you can't use future benefits as collateral for a loan.
Oh.
It helps protect veterans from, predatory lenders.
Okay, so private creditors, like banks or credit card companies, they're mostly blocked by this shield. But you mentioned exceptions. Where does the shield sometimes have openings?
The most significant one tends to be family support obligations. So court-ordered child support and alimony.
Okay. That makes sense.
But here's the critical distinction, and it's really important. VA disability benefits themselves are generally only garnishable for family support if the veteran specifically waived an equal amount of their military retired pay to get those VA benefits.
Oh, interesting. So it depends on how you're receiving the benefits.
Exactly. The VA actually looks at these cases, considers potential financial hardship for the veteran, and if they approve garnishment based on that waiver, it's typically around 20 to 50%.
So let's walk through that. If I waived, say, $1,000 of retired pay to get $1,000 of tax-free VA disability, that $1,000 VA benefit could potentially be garnished for child support.
That's the scenario where it could happen, yes, subject to the VA's review.
But what about folks getting concurrent retirement and disability pay, CRDP? They get both full retired pay and full VA disability, no waiver involved.
Right. In that case, the VA disability portion is generally protected from family support garnishment. Their military retired pay, however, is garnishable under different rules. But the VA disability part stays shielded.
Okay, that clarifies a lot. What other exceptions are there?
Well, the shield isn't quite as strong when the creditor is the U.S. government itself. Think things like if the VA overpaid benefits, they can recoup that, often through an offset. Or unpaid federal taxes, the IRS can levy funds, even defaulted federal student loans.
And is that done through a specific program?
Often, yeah. It's managed through the Treasury Offset Program, TOP. But even then, there are yearly limits, often capped at 15% of the monthly payment being offset.
Okay. And I think I saw something about VA apportionment. Is that the same as garnishment?
Good question. No, it's different. Apportionment isn't technically garnishment, it's an administrative process. Dependents can petition the VA directly for a share of the veteran's benefit. It also involves the VA reviewing for hardship, similar to the garnishment waiver situation, but it's handled internally by the VA, not through a court order for garnishment.
Got it. So a separate process. Now let's circle back to the bank account. The money arrives via direct deposit. How does that protection actually work day to day?
Okay, so there's something called the Federal Garnishment Rule. It's part of the Code of Federal Regulations, 31 CFR Part 212. It creates an automatic protection mechanism for banks. When they get a garnishment order, they have to look back 2 months. They identify any federal benefits, like VA payments, that were directly deposited during that time. Then they automatically protect an amount equal to the lesser of either the sum of those deposits or the current balance in the account.
Ah, so there's a built-in safeguard, but it's based on that 2-month look-back period.
Exactly. It's automatic, which is great.
Yeah.
But the automatic part only covers funds traceable to direct deposits within those 2 months.
So if I have, say, 5 months worth of VA benefits saved up in that account, the bank only automatically protects the last 2 months worth.
That's generally how the automatic rule works, yes.
Huh.
To protect the funds beyond that 2-month amount, you, the veteran, would likely need to go to court and file a claim of exemption, proving those older funds are also protected VA benefits.
Okay, that highlights the need for some proactive steps then.
Absolutely. Strategy number 1, always use direct deposit. It's what triggers that automatic bank protection rule.
Makes sense.
Strategy number 2, seriously consider having a dedicated bank account used only for your VA benefits. It makes tracing the money so much easier. No commingling with other funds. If someone tries to garnish, you can clearly show everything in that account came from protected VA deposits.
That seems like very practical advice. Avoids messy situations.
It does. Just one quick note on that. If you take the VA money and buy something else, like a car or stocks, that asset might not have the same special protection as the cash in the account did. It's something to be aware of.
Right, asset conversion. Okay, so let's say despite all this, a private creditor somehow gets a judgment and tries to freeze the account holding VA funds. What should a veteran do?
First thing, don't panic. Easier said than done, I know, but take a deep breath.
Okay.
Second, immediately notify everyone involved in writing. That means your bank, the court that issued the order, and the creditor's attorney. Tell them these are exempt VA funds protected by federal law.
Get it on record.
Precisely. Third, and this is crucial, file a formal claim of exemption with the court handling the garnishment. There are usually very strict deadlines for this, sometimes just 20 days, so act fast. This is your official legal statement that the money is protected.
Don't miss that deadline.
Definitely not. And fourth, be prepared to attend any court hearing. Bring your bank statements that clearly show the direct deposits of your VA benefits flowing into that account. Proof is key.
That sounds like a clear action plan, but it can still be intimidating. Are there resources?
Yes, absolutely. Don't feel you have to navigate this alone. Look for help from legal aid societies, specific veterans legal clinics, many law schools have them, or attorneys who specialize in consumer law.
And what about government agencies?
The Consumer Financial Protection Bureau, the CFPB, is a good place to file a complaint if you believe a debt collector acted improperly regarding your exempt funds.
Okay, great resources. So let's bring it all together. The core message is VA disability benefits have really strong protections against private creditors.
Definitely. But knowing those specific limited exceptions is key, especially the family support, one tied to that military retired pay waiver, and also debts owed directly to the federal government.
And those proactive steps seem vital. Use direct deposit.
Always.
And strongly consider that dedicated bank account. It just simplifies everything if there's ever an issue.
It really does. Makes proving the funds are exempt much more straightforward.
And the big takeaway, if something goes wrong, never, ever ignore court documents. Act immediately if an account gets frozen.
Absolutely critical. Time is of the essence in those situations. You know, it's interesting to think about the VA's position in all this. It's there to support veterans. It's their advocate in many ways. But it's also a government agency bound by federal law to, in certain specific cases like waivers or offsets, enforce financial obligations. It highlights this kind of complex balance, doesn't it, between protection and duty.
That's a really interesting point, how we navigate institutions that are set up to both help us and sometimes regulate or enforce rules upon us. Something to definitely think about.